there for you.
Good morning, everybody, and welcome to the investigation enforcement through lockdown and how 2020 has changed our approach. My name is Keith Owen. I'm the Director of Investigation and Enforcement Services within the Insolvency Service. I was going to say welcome to a very unusual Insolvency Live, but as it's been held up a video conference in this year, but I get the sense now that we're all getting very used to the use of VC, and I think it's going to feature an awful lot more in our lives going forward. So this session will focus on our investigation and enforcement work and how we've adapted during the pandemic. I'm sure all of you have seen changes through the pandemic and through lockdown. So we'll be looking at what lessons we've learned from lockdown, how we've maintained our delivery and working with external partners that we might make use of going forward. You will hear from one of our senior lawyers in our Legal Services Directorate, Jonathan Lupton, and one of our assistant directors in Investigation Enforcement, Tom Phillips. If there's time at the end of the presentation, we'll be happy to take questions. And if I could ask you to sort of post any questions that you have in the chat on the right of your screen. If it's not already displayed there, you'll see the chat icon sits between Leave and Settings on the top right. And if you just click or hover on that and click on it, you should be able to sort of pose a question. And I'll endeavour to cover as many as I can as possible at the end of the conference. But if you don't get your question asked, please forgive me. So without further ado, I will pass on to Jonathan and ask him to introduce himself.
Good morning, everyone. My name is Jonathan Lupton. I'm a senior lawyer and one of two directors in our Legal Services Directorate and also head up our special casework team. I'm a solicitor with 23 years post-qualification experience in the private sector, in the insolvency and business recovery sector. I'm also a former appointment-taking qualified insolvency practitioner, and in the last 2 years prior to joining the agency, I was a senior associate director in a leading insolvency litigation funding company. Over to Tom.
Good morning, everybody. As Keith says, I'm one of the assistant directors within our investigations directorate. I oversee a number of investigation teams across our southern region. My background is very much within the insolvency service. I've spent my whole career here. A lot of that time has been spent within investigation roles or supporting our investigation function. But I've also spent some time within our insolvency policy area, where I sort of developed and worked on insolvency policy, some of the legislation that we work to now, and advising ministers, dealing with external stakeholders about what goes on within the wider environment. So that's my background. Before we get into the challenges that we're here to discuss, just thought, Jonathan, I thought it might just be worth giving a little bit of background about what specifically we do within the investigation enforcement area, and what our objectives are. So you're probably aware that we're an agency of BEIS, the Department for Business, Energy and Industrial Strategy. And we support BEIS in maintaining a fair business environment and help to deliver economic confidence. We do that through pursuing a range of enforcement outcomes, criminal and civil, to tackle financial wrongdoing where it's in the public interest to take action. And I suppose our overriding objective is very much to prevent abuse within both the insolvency and wider corporate regime. So that's really the strategic piece as to why we're here. In terms of the types of investigation we undertake, as I say, it's a mix of civil and criminal. So on the civil side, we do a lot of directed disqualification investigation. So that would ordinarily be where a company's gone into a formal insolvency, the insolvency office holder will report on any matters they think need to be looked at, and then we'll have a process to identify which of those cases perhaps warrant investigation, with a view to considering whether any of the directors are unfit such that they ought not to be permitted to run companies for a period going forward. So if you like, that's a protective remedy to stop those individuals doing further harm in new companies. We also investigate on the civil side live complaints, so that would be complaints against trading companies, often from members of the public, but it can be from other regulators, from our own investigations, things that we've uncovered ourselves. And those actions are where there's some suspicion about whether a company's trading in the public interest or trading contrary to the public interest, and where that's the case, we'll go in. We have powers under the Companies Act to make sort of discrete inquiries, and some of those might be in relation to suspected scams and frauds. So you know, there's some pretty nasty behaviour that we look at in that area, and where we identify that something's going on that really ought not to be, we will take action to petition for the winding up of those companies in the public interest to prevent that ongoing harm. And the third key area of our investigation work is in relation to crime and insolvency related criminal offences. So in that area, we'd look at complaints around things like where perhaps assets have been removed in anticipation of insolvency by directors or others, or perhaps where directors have been acting as directors when they're already prohibited by virtue of bankruptcy or having been disqualified. So we'll go in, we'll make inquiries in the criminal space on that one, and those actions can lead to prosecution in appropriate cases. That's it for me now. Jonathan again. Thank you.
Thanks, Tom. So as with our colleagues in our investigation team, the functions undertaken by legal services also support the BEIS initiatives that Tom mentioned earlier, making the UK a great place to do business, helping deliver economic confidence by tackling financial wrongdoing, and also contributing to the administration of justice. We have a team of around 30 lawyers doing a mix of criminal and civil litigation work. Through delegated authority, we undertake the Secretary of State function in both criminal and civil cases of deciding whether it's in the public interest for enforcement action to be taken against individuals or companies. As Tom mentioned during his piece, the types of offences that we deal with in the criminal sphere are Insolvency Act offences, Companies Act offences, fraud and dishonesty, employment agency standard offences, and Office of Product Safety Standards. On the civil side, we deal with directors' disqualification claims, predominantly Section 6 claims following an insolvency. We deal with applications under the CDDA by directors for leave from the court to act as directors whilst disqualified. And we also deal with the public interest winding up petitions under Section 124A of the Insolvency Act that Tom referred to. We also undertake the Secretary of State function of deciding whether directors' disqualification undertakings should be accepted instead of going to the lengths of commencing directors' disqualification proceedings. So what were our objectives as an investigation and enforcement team during the lockdown period? Consistent with the agency-wide objectives of keeping our operational functions going, our objective was to maintain the delivery of our investigation and enforcement functions and to continue to support the initiatives of BEIS that we mentioned earlier. And also, as I mentioned earlier, to contribute to the continued administration of justice. We wanted to identify the areas of our operations that were impacted by the pandemic, and where necessary, take steps to introduce new measures and new procedures to enable our operational functions within investigations and enforcement to continue. But at the same time, it was important that we maintained the well-being and safety of not only our people, but other stakeholders involved in the process. We also wanted to anticipate and prepare for the future impacts that might arise as a result of the pandemic, such as COVID-related offences and insolvency volumes. So we wanted to make sure that we were preparing and looking ahead for that as well. We also wanted to take a joint-up approach across government and the regulatory landscape to identify common issues and work together with others to make sure that we develop solutions to those problems. And then going forward, we wanted to make sure that we built resilience for the agency and our directorates going forward as a result of the pandemic. So what were the challenges that were thrown at us? Like all organisations, our people had to find new ways of adapting to the challenges that were thrown at us and embracing new ways of working. To a certain degree, as an organisation, we already had a flexible working culture across some of our people and some of our functions, but there was a big difference between working 1 or 2 days a week home and having to work exclusively from home with little or no access to the offices or colleagues. Whilst many of our processes were already digitalised, a number of them remained paper-based, which was an issue for us that we had to deal with. And until recently, our IT infrastructure had its limitations. In a lot of ways, the way that we've dealt with the pandemic has accelerated the transformational journey that we've been on as an agency for a few years now. And the mindset that we've developed in amongst our people is to embrace challenge whilst maintaining the delivery of our services. So what about the challenges for investigation and enforcement? Well, these can be summarised as follows. We had infrastructure challenges around closure of offices, post, printers. We had issues around gathering evidence in the investigation sphere, the dependencies that we had on third parties there, undertaking inspections off site, undertaking interviews. We had some challenges around communications with defendants and their legal advisors at the peak of lockdown. Some practical issues around preparing cases for litigation that we had to deal with. And of course, the well-documented issue of court hearings and how they could take place in a safe environment. So we're going to look in a bit more detail at those challenges now. So hand back over to Tom.
Thank you, Jonathan. Yeah, okay. So the first of the areas there was around infrastructure. So let's have a little bit of a think about, how we managed to cope without access to offices. On the 16th of March, when the government announced that we were going to go into lockdown and people should work at home if at all possible, we took an agency decision that we would close all of our offices. As Jonathan's touched upon, some of our objectives were around, the well-being of our staff, making sure that people were absolutely safe, that customers we dealt with were as well. So that's a decision that was taken. As Jonathan says, a big change. Some people had never worked from home at all. Others had, but certainly not like this. And we weren't to know how long this was going to go on for. The immediate challenge was it seems an odd one. It's one that Jonathan touched upon about dealing with post. So with this happening overnight, there was lots of correspondence in the system. Obviously, like all organisations, we will deal with people by email where it's all possible. But a lot of people we deal with, want to deal with us by paper. Some of the banks even don't always send bank statements to us in a digital format. So we had to address that. There was posts that were still landing on our doormats, and we need to find a way to deal with that. And actually, when I think back to those times, it caused quite some frustration with our investigators, because they just didn't know. They were waiting on information. They didn't know whether it was in an office. We weren't absolutely sure, initially, whether things had been redirected and we would get them, or whether we'd need to wait till we could go back into offices. So it was really quite a frustrating period. And obviously, we contacted all our customers who we had email addresses for, to make sure that to try and generate email correspondence where we could, and that worked to a certain extent. But we're grateful to our procurement experts in the agency, because very quickly they were able to put in place alternative arrangements on a temporary basis to use external providers. So as post came into the agency, it was redirected to those providers. They scanned it in and sent the correspondence to us. So it sounds a really simple thing to do, but it really there's a lot of activity to make that happen, and some of the normal procurement rules were abridged to allow that to happen very quickly. And similarly, in terms of sending post, with everybody at home, we didn't want people going into post offices and buying stamps and sending their letters. We needed a similar process for that, and we put that in place as well. Having closed all our offices, we fairly quickly discovered too that we needed certain things or some access to offices to enable us to carry on our business and keep it going, and that was really critical. And probably the one that caused the most angst in the early days was quite a technical one. We've got a forensic computing unit, and what our colleagues there do is they forensically image and secure data of media that's been recovered as part of our investigations for evidential purposes, and it's a really important investigative function because it supports our investigation. It's about a custody chain of evidence. So it's a crucial activity, and that work is undertaken in a laboratory within our Stratford office. The way we overcame that one is that we started thinking about how we could safely get people back into the office on a limited basis. So we didn't have COVID secure offices, but we had to try and find a way to either outsource some of this work or allow our people back in to do what they needed to do. And on that one, the best solution we came up with was to do a certain amount of work within the office. We took steps to ensure that we could get our people safely back into the office on a few days here and there. And what they did is that they did a certain amount of work, and then we found an external provider that supplemented that for the foreseeable future, and that's worked really well. It's given us a really good value for money option, in the sense that we do a certain amount of the work ourselves, and then we use the external capability, and it's also given us quite a bit of knowledge about how we can work going forward. And I think more generally, we needed to go into offices for the occasional thing. So if we had a court hearing, for example, we may need to retrieve something that may have been in a box in a cupboard, or in somebody's locker. People left the offices very quickly and perhaps hadn't quite anticipated how long we'd be working like this for. So one thing we've done within the agency was to establish a critical incident management structure whereby we could escalate decisions very quickly to where they needed to go for rapid decisions. And within that process, we established a process whereby requests for access on an ad hoc basis could be made, and could be approved in appropriate cases, with risk assessments being looked at. And it met that objective that we did what we could to keep the business going within the confines of making sure all our people were safe, and that was one of our objectives, as Jonathan said. I think there's one success I'd really like to talk about as well, and that's around IT. Now, when we went into lockdown, one of the real challenges was how are we going to look after our people, ensure the well-being of our people, especially those that were perhaps a bit isolated or feeling isolated. At the time, we had some VC voicemail capability, but it wasn't a particularly mature system. And very quickly, we were on an IT transformation at that time, and indeed still are. So very quickly, we were able to put in place Skype for Business, which took us one step forward. But over the coming weeks, we actually moved to Microsoft Teams, which has really been a game changer for us. It's allowed us to run our meetings on platforms like this, to meet our teams on a regular basis like this. It's hard to imagine life without it now. And if we think back to before lockdown, we used to travel across the country to meetings because we weren't that confident about the stability of our VC connections. But now, that's all changed, and it'll be really interesting to see what happens going forward. And then the third thing last thing around infrastructure I want to talk about is having closed all offices down. We needed to make them COVID secure and capable of being reopened again in readiness for whenever the decision was taken that we could reoccupy offices on a more permanent basis. The way we approached that was to run a pilot within one particular office within our estate, probably one of the most challenging ones in truth, our Birmingham office, to look at how we could safely get people back into offices and perhaps even meet customers in offices in a secure way. So how you'd enter and exit offices, how you'd move around offices, how many desks could be occupied on any one day, what signage you'd need, all those sorts of things that I'm sure you and your organisations have been looking at as well. And having proven that through that project and tested it, we then rolled that out to other offices across the estate. We established, if you like, mini projects to work out how that could be done. And I think what's been really interesting as we've gone through this second, mini lockdown, if you like, is just having most of our offices now capable of being used gives people quite a bit of assurance that if they need an office or anything, it's there. Whereas during that first wave, it was much more difficult, and there was less certainty about how offices could be used. So that's definitely a step forward. I want to come on now, and Jonathan will come in behind me to talk a bit more about the challenges around the investigation process specifically. So progressing investigations is very much about engaging with other people to gather in information and evidence, to conduct interviews, to carry out inspections. And all of those activities took longer and were harder during the period that we've been through, and we needed to find solutions and workarounds. The first area I want to talk about is around third parties. I'll talk a bit about those we engage with within the investigation phase, and then Jonathan will talk a bit more about how we engage with directors and their advisors as we move towards litigation. So a lot of the third parties we deal with, banks, accountants, solicitors, creditors, some of those have offices, professional firms. Some of those had staff who'd been furloughed. They had staff that moved to a working at home business model, as we have, where people were in offices. There were sometimes only a skeleton staff in those offices, or for a short period, and that meant that those people we deal with didn't necessarily have access to all the records that they normally would. They don't, especially smaller firms, insolvency practitioners, for example, wouldn't necessarily have access to everything, through their IT system, and some things maybe in the office. So that was one thing we had to work around. Witnesses too. So if you think about witnesses to some of the crimes we investigate, or the live investigations, some of those people can be quite old, perhaps not comfortable engaging by email, perhaps socially distancing themselves or shielding themselves. So we had to deal with people in the way that they felt comfortable being treated and dealt with. HMRC, really important stakeholder and partner for us. So HMRC were at the forefront of trying to help, support the economy. So all those COVID support schemes They were very much dealing with all sorts of queries about those. So what the result of that was that some of the staff that support us in giving us the information about tax histories and what have you were moved to help in that top priority area. Now HMRC, we probably need information from HMRC in at least half of our investigation cases, so it is a real challenge for us about how we can keep the pipeline moving, if you like, notwithstanding not being able to get all of that information. And I think in all of these areas, the way we overcame these sorts of challenges was to liaise really closely with our stakeholders and customers, to try and find the parameters within which we could get some of the things we needed, to perhaps identify what our top priorities were and get those sorts of information in, to just keep things moving as best we could. And I think the work with HMRC was a really interesting one as well, because it really highlighted our dependency on that organisation and actually a small number of people in that organisation for giving us the information that we need on a day-to-day basis. And I think what it's done is probably accelerated thinking around digital solutions. How can we work together to get more intelligent ways of passing information to us? And I know that the IT experts in both departments are looking at that, how we can automate that process so we get that information that we need and are entitled to get hold of in the most easiest way. Moving on a bit to inspections and work off site, clearly with travel restrictions, rules around social distancing, the need to get hold of PPE before we went out, life was just a lot harder in that area, and there's a few areas of our business that was really significant. So I've already mentioned that work that the forensic computer unit do. They sometimes go out on site and image big IT systems on investigations, some of the big investigations. When we go out, we're obviously reliant on other people as well, so partners in that work. So it might be an administrator, it might be someone else who we're going to encounter or need the support of. I think the other big area, this is a big impact, was on our live investigations. So that's those investigations where we're there to try and stop harm that might be ongoing. So we want to get out as soon as we can to see what's going on. So those visits are sometimes unannounced. We undertake those right across the UK. So there's travel issues there. We're going into environments that we don't necessarily know what we're going to encounter. So we did recognise those risks were too great during those early weeks, and it's something that we had to work around, or actually pause was the reality of it. But as soon as those restrictions did start to ease, we started to really look very carefully at how we could safely carry on our business, how we could pick up some of those inspections in particular, how we could risk assess, and we started it in a very measured way, on the types of case that we knew from experience we wouldn't encounter to great contact with others. And that gave us the assurance to build that up. Our investigators, credit to them, were really keen to get on with things, and they really wanted to run the business and support the business, which is, like I said, a great credit. But that's the way we've dealt with it. And actually, those sorts of inspections, particularly on the live companies, we've managed to maintain those through this recent lockdown, which has been great by and large, anyway. And the last area, before I'm going to pass back to Jonathan to say a bit about directors and defendants, is around conducting interviews. So another important part of our process, not too dissimilar to those inspections, is how we could conduct interviews with directors, suspects, to give them the opportunity to give their account of what had gone on from their perspective, and that's an important element of the investigation process. In crime especially, we do conduct investigations under caution. So just because seeing a suspect is an essential piece of business for us, it doesn't necessarily mean it's going to be essential for them. Some suspects actually want to come in and be interviewed and sort of clear their name, so to speak, and stop the investigation. Others are going to be more reluctant and may even consider it oppressive if we put pressure on when we're in lockdown. It's technically possible to undertake interviews in this sort of way, in a remote way, but it all comes down to the security around your infrastructure. And the advice we were getting at that time is that for crime interviews where we need to record and safely secure the transcript and content of those interviews, it's not something that we could do. So that was more difficult. One thing we did try was to conduct interviews with suspects and even directors by correspondence. So we could inquire by correspondence, say that their answer given under caution, but it's a bit limited that because you lose that interaction and immediate ability to respond. So it had its limitations, but it's something we did try. But I think across the piece here, what I would say is we were trying different things. We were trying to do things in a different way. We were feeding more new investigations into the system to get things started and keep people productive, and do what we could in each of those areas. And we've generally kept things moving, which is a great credit to the people in the organisation that do that work. That's all for me from now. Jonathan, I'm going to pass on to you for something about directors and advisors.
Thanks, Tom. As Tom mentioned, one of the big issues that we had during the peak of lockdown was dealing with physical post, which gave us a bit of an issue with how we could correspond with defendants, particularly those without legal advisors, where we didn't have email addresses for them and had to use the physical post. And we had to come up with alternative ways, not only of communicating with those defendants, but also alternative ways, as I'll come on to later, of serving them with the proceedings so that we could keep the proceedings and keep the enforcement function moving forward. On criminal cases, this was to a certain degree less of an issue. We were able to move rapidly to serving proceedings electronically by email. The criminal procedure lent itself to that, enabled us to send a test date email to defendants, and provided that they acknowledged the emails. As long as the defendants acknowledged the test email, then we were able to serve them in that way. We had to make adjustments regarding the way we served the proceedings, because previously we'd serve a requisition with a date to attend court, together with the evidence, so together with the statements and the exhibits, and those documents could be quite bulky and quite voluminous, with lots of documents to those. So we had to try and streamline, that process. And what we did was we moved to serving the requisition, but with a detailed case summary initially, and then where one was necessary and where one was requested, we then later serve the defendants with the evidence, with the statements and the exhibits. On the civil side, we experienced some reluctance, or certainly difficulties with some defendants in them engaging, or difficulties around them getting legal advice at the peak of the pandemic and at the peak of office closures, which caused us some delays in the process, particularly with regard to us having to comply with pre-action conduct and pre-action correspondence. We had a particular problem with serving defendants where we didn't have an email address or a telephone number for them. As Tom mentioned, the issues that we had with post at the peak of lockdown, we couldn't serve them by post whilst our offices were closed. And where we did have an email address, the civil procedure rules only allow us to serve by email where we've got prior written consent from the defendants, which in a lot of cases they were reluctant to give us. So the way we got around that was that where we had email addresses, we would proceed and we'd attempt to serve by email. and then when we got to court, we'd seek retrospective leave from the court under the CPR to serve by alternative method, and in most instances where the court was satisfied that the email had been received and that defendants were aware of proceedings, the courts were prepared to grant us that relief. And then by June 2020, as Tom mentioned, we had put in place external suppliers to deal with our printing and physical posts. So that then enabled us to serve by post in the usual way on those defendants where we didn't have an email address. So all that together effectively enabled us to keep the enforcement and the litigation process moving forward. Again, as a result of issues with office closures, we weren't able to receive hard copy undertakings from defendants. Those are undertakings to not act as a director for a certain period and avoid the court proceedings. So we introduced a process whereby we would accept electronic signatures on those documents, and we would put our own electronic signatures on those documents, which was all valid, provided that we kept proper audit trails of the email exchanges, bringing about the electronically signed undertakings in place. And that again enabled us to keep the process moving forward and avoid, where possible, the need, to go into the court system. Service of winding up petitions on the live winding up public interest cases were temporarily hampered at the beginning of lockdown due to our service agents having to stop operating, but that was quickly overcome with those agents putting in place measures to enable them to carry out their services in a COVID safe environment, a COVID safe way. So as you'll hear when I talk about the courts, we were able to predominantly keep the public interest live winding up work moving forward and was largely unaffected. We did have some issues around preparing cases for litigation, particularly with the disqualification cases. So disqualification claims are supported by affidavits and exhibit bundles, which need to be sworn under oath before a solicitor or a commissioner for oaths. And as Tom mentioned earlier, many of the solicitors that we used to do that were either closed or operating on skeletal staff or on a limited basis, which made it very difficult for us to get access to them, as well as the fact that our offices were closed and people weren't going into the office, caused difficulties around that too. Preparing paper bundles in our remote office locations was a problem, particularly at the peak of lockdown. Our people weren't going into offices, and that caused a difficulty there. We also had security issues around emailing off our secure network court bundles and document bundles to solicitors that weren't involved in the cases for the purposes of possibly doing remote swears, which we know were introduced across the private sector, and because of the security issues around that, we were a bit reluctant to do that. So what we introduced was the use of electronically signed but unsworn evidence in our proceedings, which was backed up when filed at court with a solicitor's undertaking to file a sworn document as soon as we were able to do so and as soon as the restrictions were lifted. And this found favour with the judges whilst the restrictions of the lockdowns were in place, and this enabled us to continue to issue our claims and avoid building up unnecessary backlogs. It then, however, created a potential issue for us further down the line as the lockdown restrictions were lifted, and we saw an increasing number of judges then insisting as a result of that on cases, affidavits being sworn before the cases were able to progress, and this built up and has built up a backlog of cases that we need to get sworn and get back into the system. We looked at getting around that in between the two lockdowns, so the first lockdown and then the regional, and lastly the national lockdown, we introduced bulk swear days where we'd get solicitors into the office and do bulk swearing, which helped relieve that backlog. But of course, you know, the national lockdown that's been introduced now has put paid to those. This wasn't so much of an issue with the public interest winding up cases, because public interest winding up cases are supported by witness statements and not affidavits, and under the civil procedure rules were entitled to, or were allowed to, sign witness statements electronically anyway, so it wasn't so much of an issue there. And it made us think as to whether or not there's an opportunity going forward with disqualification cases, as to whether we should move away from the use of affidavits, like is the case in most court proceedings, and going forward using witness statements. And that's something that we will endeavour to pick up with the various court user groups and look into that. And then we had the issues around court hearings themselves, and where the courts were closed or they were otherwise unable to accommodate physical hearings, the court service and the judiciary and other court users had to adapt to different ways of dealing with court hearings so that administration of justice can continue and that we weren't experiencing, you know, significant build-up and backlog of cases in the court system. And the solution that was introduced was the use of remote hearings and remote trials through the use of Skype for Business initially, then lastly Teams. The cloud video platforming was introduced into the criminal process, and telephone hearings were also used in the county courts. The introduction of hybrid hearings, so a combination of a hearing where there's some physical attendance and some attendance remotely, was introduced. The use of electronic hearing bundles was introduced, so the courts quickly adapted and court users quickly adapted to the filing and use of electronic hearing bundles for hearings. And in some instances, there was a pragmatic approach taken by some of the county courts to the restrictions that were in place there in relation to what could be filed electronically in the county courts. On the criminal side of things, we initially saw many adjournments, whether they were first hearings or trials, because of issues and concerns around the safety of attendees, particularly juries. Whilst we saw Nightingale courts open up, this didn't assist us too greatly because our cases weren't prioritised ahead of the custody cases and the more serious cases. So that led to a lot of our criminal cases being adjourned. The criminal team needed to be proactive and plugged into the liaison group that had been set up with the Court and Tribunal Service, and to gain useful insights as to what was going on in the criminal court system. And measures are now in place for secure jury trials to take place. Whilst that's the case, there still remains quite a backlog in the criminal court process, and it remains to be seen, you know, how long that's going to take before that's cleared. The criminal courts moved very quickly to accepting court papers electronically, which was obviously useful, particularly at the peak of lockdown when we had the restrictions, you know, around physical post. And recently, we've been informed that we will get access to the digital case system that's used in the Crown Court for cases, which is going to assist us greatly. There were a few hearings in the criminal system that did take place, and where they were able to take place, they did take place remotely via Skype for Business and the cloud video platform that they'd introduced. And again, you know, this was helpful in, you know, reducing the backlogs and helping, you know, the process move forward as best we could. Within our team, we formed a group really just to keep an eye on things and make sure that once the criminal cases started to get back into the system, particularly the trials that had been delayed, that we were ready to go and ready to progress those cases once they came back online. On the civil side of things, Initially, the cases that we had listed in the High Court in the Rolls building that were listed before the 30th of April were adjourned generally. That was with the exception of our live public interest winding up cases, which were deemed a serious priority cases, and therefore those cases largely continued to be dealt with through remote hearings as normal, and we were able to progress those cases through the court system. We experienced a lot of adjournments in the regional business and property courts too, and the county courts also, particularly in the early stages where steps were put in place to adapt to and introduce the use of remote hearings through video conferencing and telephones. That caused us some delays, although most of those cases are now back into the system and have been given new hearing dates, albeit with those dates being pushed further down the line. I'm pleased to say that in some instances, in quite a number of instances, there was little or no delays with court hearings, where the courts and the judges adapted very quickly to the use of remote hearings, which enabled some of the cases that we had in the regional courts and the county courts to proceed without any significant delays. I mentioned earlier the liaison group that we set up with the Court Tribunal Service, and this was a regular feature both across civil and criminal and our official receiver services who also attend court. And we have this liaison group that initially met weekly, then fortnightly, and I think it's now meeting on a monthly basis to discuss practical issues around use of the courts and use of the court process. And this proved really useful to us during the lockdown period. And it's hoped that that dialogue with the Court Tribunal Service will continue moving forward, because it was really helpful to us. We took steps to issue, where we could, a lot of our claims in the High Court. The public interest winding up cases have to be in the High Court. Disqualification cases, we do to a certain degree have a choice, but we took the steps to, during the pandemic, to issue in the High Court. And this was primarily to avoid the administrative issues which were being experienced in the county courts, who were severely impacted as a result of the pandemic, which was largely, I think, due to the fact that their systems and processes didn't lend themselves to dealing with claims electronically. So in terms of the courts generally, the move by the courts and court users to technology in both civil and criminal is a really good news story. The pandemic has effectively brought forward the use of remote hearings. It was on the agenda and it just accelerated bringing that forward. Whether or not it will remain when we eventually come out remains to be seen, but recent suggestions are that it's likely that remote hearings will stay, and I could certainly see that being the case, particularly for the smaller hearings, direction type hearings going forward. Whilst there were some inconsistent approaches taken by judges over the use of remote hearings and technology in the early stages, overall they embraced it like everybody else, and again it just helped the administration of justice and kept our processes moving forward. And I alluded earlier also to the pragmatic approaches that judges took to dealing with technical issues that arose during the litigation process, particularly, as I mentioned, the use of electronic unsworn documents in the interim period during the peak of the lockdown, and when we couldn't access offices and get documents sworn. So I'm going to hand back to Tom now, who's going to have a look at lessons for the future.
Thank you, Jonathan. I'll be quite brief, so there's a little bit of time for a few questions if there are any. But like all organisations, we're looking at what we've learned through this process, and we've touched upon some of that as we've gone through, and a couple of things are quite striking. We've collaborated really effectively with external partners, both within government and externally, and it's really great to hear some of what Jonathan's been talking about there, about the way some of our partners have been adapting and doing things differently, which, you know, bodes well for the future. I think another big area has been around the way intelligence functions within government have come together. You've probably picked up in the media the concerns around fraud and abuse in relation to COVID support schemes. You know, we've really joined up with others within the economic crime landscape to discuss and think about how those issues are best addressed right across government. Internally, our people have really come together and shown great commitment. We've worked across functions, you know, within the agency very, very well. Even very junior staff have been willing to put themselves forward to help, for example, with our redundancy payment service, as you know, the numbers of redundancy notifications have come in to be dealt with. So that's really great to see that. And then in relation to our investigation activity specifically, we've found ways to keep things moving, to keep that pipeline moving. So yes, there are some blockages, but at least that means that once those blockages start to ease, we will be well placed to maintain the standards that we've come to expect. Jonathan's touched upon remote working a little bit. That's been a big one, you know, within the agency as well. And you know, we've really got used to dealing with people in remote locations, to bring teams together, to use that technology to optimise the way we work, which is fantastic. And I think what we come out of this with is a more resilient organisation, and you can already see that as we've gone through this second lockdown. More confidence, more assurance that we've put the processes in place that can support the business, be that temporarily or for the longer term. And we've really proved to ourselves, as much as anybody else, what's possible. And there's definitely lessons that are going to be coming out of that. So, you know, we're in a sector that is going to face unprecedented challenges going forward, probably. So, you know, we that resilience we will want to be drawing on, and you know, that commitment and like I said, that working right across, you know, with our partners to deliver our business as best we can. At that point, I'm going to pass back to Keith. Thanks very much for your time, and but any questions?
Okay, thanks, Tom, and it was a fascinating sort of walk through the past year, and what a year. It just makes us realise how we've sort of raised to the challenge of what the pandemic has brought our way. But there's also, to me, it's clear that there's really some excellent opportunities for new ways of working. So thanks, guys, for that. A couple of questions we have. Probably one for you, Tom, here in terms of prioritization, and how do we prioritize what we do? And has the pandemic caused, you know, us to approach anything differently? Over to Tom.
Thank you, Keith. I think generally speaking, we prioritise by reference to the level of public interest. So as I said, you know, everything we do is driven by, you know, what are the public interest outcomes that we want, and part of that includes consideration of whether there's ongoing harm, and there's a number of factors that all come into play there as well. I think you know, in many ways the investigations we've got in progress were those that had been started, you know, or we'd seen before the pandemic came. But one of the things we are starting to see now is some of those abuses, you know, in relation to COVID support schemes, particularly on our director disqualification side. And they absolutely do carry a higher level of public interest, and we are giving them appropriate priority, you know, as we see them. You know, those matters will ordinarily be reported to us through the director conduct reporting system, and we'll pick that up within the disqualification process, definitely. And it's a question as well for the other disciplines. So the live investigations, we've seen some COVID-related cases there, and you know, there's, as I say, there's an ongoing discussion about how to deal with COVID frauds or suspected frauds right across government, but we are very much part of that. So I think what you'd say is we're taking a proportionate approach as we go through. We're carrying on with what's there, but we are actually recognising that there are a wave of cases coming through now which are affecting our thinking and some of what we'll be prioritising for work in the months ahead. Thank you, Keith.
Okay, thanks ever so much, Tom, for that. And there's one here for Jonathan. Really, in that we haven't always had an in-house civil litigation function. This is almost 2 years in now, and I'm wondering if you'd like to tell us how you think that's going, how you feel that's going.
Thanks, Keith. That's a good question. I think it's fair to say that so far it's been a real success, and I don't just say that because I'm one of the civil lawyers that was recruited to help take it forward, but it has been a real success. The decision was taken in June 2018, I think it was, to introduce the civil litigation function within the Insolvency Service, to take up and deal with directors' disqualification claims and public interest claims. And this was to run alongside the already well-established criminal prosecution team that had already been built up and introduced to the Insolvency Service a little earlier. And I think it was by August 2018 we recruited our first civil litigation lawyer into the team, and then that was quickly followed by us getting processes put in place for conducting the director's disqualification proceedings, and then latterly and more recently processes in place for conducting the public interest winding up work in-house. We've now grown to 13 lawyers within the team now, dealing predominantly with civil litigation, a mix of disqualification and public interest work. We've also added to our paralegal officer resource to help support those lawyers and build greater capacity within the team to be able to take on greater volume of cases. And in the 2 years that we've been dealing with this, we've dealt with 670 disqualification cases in-house, which I think demonstrates success. And we've also dealt with 22 live winding up cases, which we have only been doing within the team for about 12 months. And so you can imagine, with bringing that work in-house, the savings that we have made with our legal spend in dealing with those. So overall, it's a good success so far. You know, we're bringing the work in. You know, we're processing it, we're getting it done, and you know, we'll just build on that moving forward.
Thanks for that, Jonathan. I think we're coming up to our time now. You know, the past hour has flown by, and I just want to thank Jonathan and Tom for a fantastic presentation. Little trip down memory lane for me into all the challenges that we've met over the last year. And as I say, I think there's some real opportunities for new ways of working, and I'm looking forward to the challenges of the coming year as we go on. So I just want to thank everybody for coming along and listening. I hope you found it enjoyable, and look forward to seeing you all back in the wide open spaces of our offices very soon. Thanks ever so much, and bye.